it's really important before I kick off this to show everyone watching it. And again, I'm getting tangled up in my own wires like I normally do. I'm going to show everyone this because I think everyone should see it. Let's have a look. Cancel. Let's go for that. And then I'm going to show you another couple of bits before we do that. Right, so everyone's seeing this. This is a document. It's called We the People. The Constitution of the United States. Its only keepers, the people, George Washington. Right, and then inside it gives you. By the way, if you are made an American citizen, you're given this, and it is everything in there written down. What I wanted to try and do was explain to people the Constitution of the United States with index, Declaration of Independence, and it also then goes through the Constitution, the articles, etc. There's another part I could go through there, which I'm not going to, but I am going to go to the amendments. All right, so the amendments are here, and this is all in one little pamphlet. You've got the preamble to the Bill of Rights, and it says the conventions of the number of states having, at the time of their adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. So, restricted the government, right? This is people should really understand what's going on. That further declaratory and restrictive clauses should be added, and as extended the ground of public confidence in the government, will best ensure that the benefit ends of its institution, resolved by the Senate, and then it says articles, and then it goes through and it tells you what they are. Now, making sure that you understand this, you've got Article 1. The first 10 amendments, Bill of Rights, were ratified on effective in 1791. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assembly and to petition the government for redress of grievances. Right, all of that, in effect, comes from England. All right, so much of this does. Amendment 2, a well-regulated militia being necessary to the security of a free state. And free state means each independent state of the United States, independent states of America, right? It was never supposed to be one complete country. The right of the people to keep and bear arms shall not be infringed. Now, where did that come from? Well, what I'm going to do, hopefully, tonight is just to show you a few little parts of this, because it really is about our ancestors and the way they actually stood up and said, basically, F you to the government, right? And anyone else who tried to stop them. This is the English in particular. So the recent case, October term 2025, this was, but the final ruling come out the other day. It was decided June the 18th, 2026, right? Supreme Court of the United States. Now, this is unusual because all 9 of the Supreme Court justices completely agreed. So it was a 9-0 ruling, right? A bit like when we had a 3-0 ruling in the appeal court in the Royal Courts of Justice. Now, the Supreme Court of the United States of America, to give you an indication, I'm going to read out the first part of this so you get an indication of what I'm saying. United States versus Hemani, certiorari, in other words, a declaration to the United States Court of Appeals for the Fifth Circuit, right? So that's like our equivalent is our appeals court, then appealing it as on a point of law to the Supreme Court. Ali Hemani is a dual citizen. There's them dual citizens cropping up again, of the United States and a Pakistan and he's a dual citizen of the United States and Pakistan, who was born in Texas. He has spent most of his life living in Dallas area with his parents and working a stable job. Suspecting Mr. Hemani and his family members of terrorism-related activities, the government conducted a search of the family home in 2022. Throughout the process, Mr. Hemani proved cooperative. He surrendered a gun he kept in the house, pointed agents to some marijuana on the property, and consented to an interview during which he told law enforcement agents that he used marijuana about every other day. Now, why is all of this important? Because they're setting the scene not just for this case, but for other cases. So what I'm going to do is go to another amendment. Well, actually, there's a few amendments here, but I've just got to make sure that people actually get what I'm talking about, right? So I'm going to show you something else. Oh, it means I'll have to take that off the share. Put this on there. Can you all see that one there? Remember what's happening currently with Charlie Staples. This is Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise be re-examined in any court of the United States that according to the rules of the common law, right? So the common law says once the jury's made its decision, that's it, right? Again, excessive bail should not be required. This is the next one down. Nor excessive fines imposed, nor cruel or unusual punishments inflicted. Comes directly from the English Bill of Rights. The erasure in Constitution, certain rights shall not be construed to deny or disparage other retained by the people. Right. The power not delegated in the United States by the Constitution nor prohibited by it to the states are reserved for the states respectively or to the people. In other words, via referendum. And the important parts. There was a particular one that I was looking for because it was absolutely English in its terms. And I'm sure it had something to do with, it may have been that side of it. Amendment 5 or the Fifth Amendment, and then there's the Fourth Amendment, which I'll go into. The Fourth Amendment is quite important. And this comes from England, right? So all I'm doing is trying to make sure you can read that on your screen, right? The right of the people to secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation. In other words, the judge must sign the warrant and must swear an oath that he believes that probable cause exists, and particularly describing the place to be searched and the persons or things to be seized, right? Why is that important? Because this relates back to the Second Amendment in this case, right? So just to make sure everyone's got this, what I'm going to do now is go back to my Facebook camera and go back and tell you what this is all about, right? But I'm now going to I'm going to show you that and then take you back through some other stuff that's just as important. Let me bring that in. Al Hemani, dual citizens, etc. And then it goes in and it tells you what he did. So Mr. Hemani admitted the use of marijuana, but the government prosecuted Mr. Hemani under 18 USC 922 G3 for knowingly possessing a gun in his home while being an unlawful user of a controlled substance. Mr. Hemani moved to dismiss the indictment, arguing that the government effort to enforce blah blah against him violated the Second Amendment. The district court granted the motion, and after an unsuccessful appeal to the Fifth Circuit, the government asked this court to review the case, right? Because they thought that the Supreme Court was going to step in and back them up, right? Held. The government's prosecution of Mr. Hemani under Code 922 G3, unlawful user provision, is inconsistent with the Second Amendment. Pages 3 and 19 as you go down. The Second Amendment protects the right of all Americans to keep and bear firearms for self-defense. District of Columbia versus Heller, right? So it then talks about, everyone's heard me talk, should have heard me talk about Justice Scalia and Heller, right? Now this is important, this case, so I'm really grateful that Jason flagged it up to me, because there's another case that it mentions, which is here, the one I'm just about to highlight here, right? And it tells you that it is a well established, and the right to keep and bear arms is a pre-existing right. So again, it was established in Brune, it was established in Heller, and it's now been re-established in this case as well. This is 9-0, and it's been almost annihilated, the case against them. Now, before I start getting into too much of this, I'm now going to go into the next part of the case. This is literally a flying chat about it. But I really want people to understand. There's a funny bit coming up. Why this is so important to us? Because America is a common law jurisdiction. The Supreme Court is the highest common law jurisdiction anywhere in the world. I would say now it is far in front of the English Royal Courts of Justice, because of their populace, right? In other words, there's so many of them that they now outnumber us so much that you would have to take note of their law, right? And in law, you can use Supreme Court cases in other common law jurisdictions in your own defence and in your own case. I want everyone to remember that, right? So in this case, District of Columbia versus Heller, I'm going to take you to a couple of bits that are really important, right? Which is this bit here that I've highlighted. Meaning of operative clause. This sounds technical, and I'm jumping right in the middle, so you won't get it until I get to the other points. Putting all of these textual elements together, we find that they guarantee the individual right to possess and carry weapons in case of confrontation. This meaning is strongly confirmed by the historical background of the Second Amendment. We look to this because it has always been widely understood that the Second Amendment, like the First and Fourth Amendments, codified a pre-existing right. Pre-existing, it came from England, not the British, the English jurisdiction, right? The very text of the Second Amendment implicitly recognises the pre-existence of the right and declares that only that it shall not be infringed. As we said in the United States versus Cruikshank, this is not a right granted by the Constitution. This is so important, right? It is not a right granted by the Constitution. Neither is it in any manner dependent upon the instrument for its existence. The Second Amendment declares that it shall not be infringed, right? What people listening to this won't understand the crucial element of what his words were, right? And if I'm really honest, in terms of historical inquiry, I don't think he realises, right? But I'm about to tell you how this all fits together. Between the Restoration and the Glorious Revolution, the Stuart kings, Charles II and James II, succeeded using select militias loyal to them to suppress political dissidents, in part by disarming their opponents. See J. Malcolm, to keep and bear arms, thereunder Malcolm, and then L. Schroeder, the Declaration of Rights, 1689, page 76, 1981, under the auspices of the 1671 Game Act. For example, the Catholic James II had ordered general disarmaments of regions regions that were home to his Protestant enemies, right? And again, what I'm going to do is lean across here and show you something else, because I know you like it when I show you things, right? I know you're all smiling away in the background, right? So just to show you this, I'm gonna stop that share. I'm coming back to this, right? But I need to show you this share there. Here is the actual book that Justice Scalia has mentioned in that book. It's the main book that I use to explain to people what the Declaration of Rights was in England and what the debate was at the time, right? So there it is, the exact book and original from 1981 that Justice Scalia had used. And here is literally at page 76. So that is the page that he's talking about, right? You're not going to be able to read it all, and I'm not going to read it all out. But it tells you in here the exact history from the debates itself, why it was we have a right to keep and bear arms. And when you...
The English Constitution is the solution, always has been and always will be.